Okay, good morning. Welcome. I'm now going to call this meeting to order. My name is Dawn Dirksen, and I'm the Vice Chair of the Real Estate Board. Chair Juarez is not able to make it here today, so I'm standing in to chair this meeting. I want to welcome all of you to the meeting of the Oregon Real Estate Board. I will start the meeting by explaining the membership of the board, the duties of the board, and Oregon public meetings laws, and then let you know when or what to expect at this meeting. The board meetings the board meets at least 6 times a year, holding 4 meetings online in a video conference format and 2 in-person meetings held in communities around the state. The board consists of 9 members appointed by the governor who serve a 4-year term. 7 members have 5 years of active real estate experience, and 2 members are public members. Public members are not real estate licensees and may not have been employed by the real estate agency. Given our full agenda today, I would like each of our board members to introduce themselves briefly, and will hold off on the market updates until the next meeting. So let's see, I'll start with me. So I'm Dawn Dirksen. I'm a licensed property manager. Let's go with you, James. You're the next face on the screen.
Good morning. I'm James Comer with Two Rivers Mortgage. We do residential real estate financing in Oregon, Washington, and California.
How about you, Michael?
Michael Warren. I have Cook County Properties in Prineville and do residential, commercial, and bare land.
All right, Stacy.
Good morning, everybody. Stacy Ellingson with Fisher Nicholson Realty down in Klamath Falls.
Good morning, Heidi.
I'm Heidi Hazel, authorized principal broker for Berkshire Hathaway Lake Oswego.
Good morning, Tom.
Good morning, everyone. Tom Tappy here, Fratsky Commercial Real Estate. Specialize in office medical, industrial, and land sales.
Good morning, Latasha.
Good morning, Latasha Beal, licensed in Oregon and Washington, serving Portland Metro and Clark County.
Did I miss anyone?
Me.
Oh, I did. I'm so sorry.
That's okay. Deborah Neal, principal broker with Windermere Realty Trust.
Okay. Welcome. In all matters relating to board business, board members represent the governor and serve at the pleasure of the governor. The members of the board are entitled to compensation for their expenses related to board business and receive a stipend of $178 per day when conducting board business. Also at the table is the real estate commissioner, Steve Strode, who's appointed by the governor in 2019, and deputy commissioner Anna Higley. The board has 5 primary duties: providing advice to the real estate commissioner and the government's office regarding real estate industry matters, reviewing proposed rulemaking and providing recommendations to the real estate agency on rules, reviewing and improving or denying experience waiver requests from applicants for a principal broker license, making recommendations or suggestions regarding the license examination process, approving or denying an applicant's qualifications to be a continuing education provider if the applicant does not otherwise qualify under the statute, contributing to the development of and approving the law and rule required course biannually. Oregon public meeting law requires that the public be made aware of the decisions and deliberations of governing bodies. The real estate board is called a governing body under the law and is therefore subject to Oregon public meeting laws. The key requirements for the law are to hold meetings that are open to the public, give notice of the meetings, which we do by posting the schedule and the agenda on the agency's website, take minutes of the meetings, which we do by recording and taking written minutes of the meeting, both which are posted on the agency's website. The real estate board gives Robert's Rules of Order, which provides common rules and procedures for conducting meetings and for deliberation and debate in order to place the whole membership at the same level. The board cannot make a determination unless it has a quorum, which means that 5 members of the board must be present. In order for the board to make a decision, a board member must first make a motion, which must be seconded. The chair must then state the motion, followed by a debate. Finally, the board members must vote on the motion. All votes are recorded and documented in the meeting minutes. The board must follow the statutes and the rules under the Oregon Real Estate License Law, which is ORS Chapter 696. Today, the board will follow the agenda. First, we will allow any members of the public to speak to the board. The board cannot take any action at this meeting on citizen comment. After that time, or after the time open for public comment, the public may not speak on any matters before the board, and the board may not take direct questions to the public. The board may ask the real estate agency to provide technical information. The board will take up matters that require board action or recommendation to the real estate agency, followed by new business. So then so now we are at, for the meeting agenda and order of business, do I have, oops, I'm sorry. So now are we asking for a motion to approve the agenda?
That's right.
I will move that we approve the agenda as written.
Second.
All in favor?
Aye.
Aye.
Any opposed? Any discussion? Okay. So then the next thing would be to get approval of the previous meeting minutes. So for what month are we in? June? So this would be for March meeting minutes, correct?
April. And you'll
April.
offer
April.
discussion
Oh,
first.
April meeting minutes.
Yeah, April meeting, you'll offer discussion first and then entertain a motion.
Okay, is there any discussion needed for the April meeting minutes? And does anybody want to make a motion to approve?
I'll make a motion to approve the minutes from April 6th meeting.
Well, second.
Any opposed? Or discussion? All in favor? Sorry, all in favor before opposed. All in favor. Is there any opposed? Okay, perfect. Okay, so then we're gonna look at the date of our next meeting. The next meeting for the real estate board will be held on August 3rd, 2026 at the Oregon Real Estate Agency office in Salem. Do we have anybody that has signed up for public comment?
I don't have anyone signed up.
Okay,
Not seeing anyone in the
Doesn't look
chat.
like anybody else. No.
so now we have request for waivers. So then we are going, is this me, Anna?
You can bring Tanner Dunbar on. Just
Okay,
invite him on camera and then allow him to provide his presentation to the board.
all right. Tanner Dunbar, are you ready to give your presentation to the board for your request of waiver?
I am Chair Dirksen, yes.
All right, we are ready for you.
May I turn on my camera?
Yes, please.
Oh, yes, please.
Am I visible? Maybe.
Yeah.
There we
you
go.
are.
Hello. Hi, everybody. Thank you for allowing me to be here today. I am Tanner Dunbar. I am currently a licensed broker in the state of Oregon. I operate under Cherie Belander Real Estate here in the Columbia River Gorge. I'm in Hood River, Oregon, serving Wasco, Sherman, Hood River County. I am here today just to ask for a waiver for the time that is required as a broker, monitored by a principal broker, for various reasons. My main concern is a conflict that I am facing with any other brokerage out here in the Gorge. I own a property management company out here, Premium Property Management of the Gorge, LLC. I call them Premium just for abbreviation, but I opened Premium September of 2020, right before COVID, and have operated it until October of 2024, when I decided to become a broker. When I got a broker's license, I was shopped around, visited numerous brokerage companies, principal brokers, met with various people, all of whom asked that I either dissolve my current company, my property management company, or I sell it. And that just wasn't feasible or recommended in my eyes. But I did find Cherie Belander Real Estate, who was willing to work with me. So we assigned my company over to Michael Waterman, who now oversees Premium Property Management, and I now operate under Cherie Belander Real Estate. But as of this year, January, Cherie informed myself and another agent that works for us, Megan, that she was looking to retire the end of this year. So end of high season is what she is expecting. So we're expecting September, October time, probably she's looking to retire. And prior to dissolving my company or reassigning all of the property management agreement, having Michael reassign all the property management agreements out and shopping at a new brokerage, I just wanted to request a waiver for my time that's required per the real estate rules and regulations.
Does anybody have any questions for Tanner?
I do, Chair Durgeson. Tanner, hi, thanks for coming. Hey,
Thank you.
On your application, the experience requirement waiver request, it said, I'm currently licensed, held real estate license, another state issued by a state's like, and you marked yes and no. What, I just curious.
Yeah, so that was actually at the advice of Darvel Nina, I think it was. Originally, I marked no, as I don't hold a license in any other state. But via email, she asked me to select yes and then disclose my property management license and then my real estate broker license.
Okay.
And so that was to her discretion. She says that it was an older form that was currently being revamped or looking to be revamped. So she said that it was hard to understand, but that was at her discretion.
Okay, no, that's fine.
Perfect.
I've got a few questions here, so hang tight.
Yeah, of course.
Something you mentioned when you first started talking so when you became a licensed broker and you went underneath Cherie,
Yep.
At that time you didn't know she was retiring.
I did not know she was retiring. No, our plan was actually to finish my full 3 years with her. And that was the talks. And she actually brought on another individual, same talks. And then she's had some life changes. She's had, some passings in her family. And then January 1st is when she advised us that she's looking to retire.
Okay. And then I'm just going to go through all my questions then while I've got you here. What, that answered quite a few right there. But so just as a ballpark, I don't expect you to have a list, but how many transactions did you do buyer or seller side last year?
I do have a list of that. 1, 2, 3, 4, 5, 6, 7. I did 9 representations, buying and selling. That was, yeah, 9 and then 1, which was closed the end of this year. So 9 total for the year of 2025.
Okay. Okay. You answered quite a few within that one question, so I'm done.
Okay.
Thanks.
Yep. Thank you.
I'll follow Michael's train. Thanks for being here. It sounds like you don't plan to take over Cherie's business. It sounds like you will start your own firm that will include the property management and real estate. Do I understand that correctly?
Yeah, so that's my ultimate goal. My plan is to continue to work under Cherie just until she actually retires, just gain that knowledge. But I'm not looking to assume her business. I'm actually looking to go back to premium property management and then incorporate sales should it be necessary at that time.
How big is premium property management right now? Like,
Premium property management, I haven't been in the books too much just because I've been really hands off operating on the broker side. The last connection that we had was in March 20th was the last meeting that I held with Michael. At that time, they were managing 600 units, and that was about 20 different owners.
nice. And do you have a plan at all to supervise licensees once you move into Tanner's Property Management and Real Estate World LLC, or whatever that looks like for you?
Yeah, I think I would like to just get back into the reins of things and kind of get back into like the day-to-day aspects of the property management side. And then I'm very like goal oriented and timeline oriented. So my 3 to 5 year plan would be yes to potentially bring on other agents. But I just want to make sure that I'm comfortable and I'm not looking to potentially ruin someone else's career by biting off more than what I could chew.
Right. And in your real estate experience, how has that been for you? Have you experienced those challenges? Have you had tough conversations with sellers, with buyers, with listing agents and buyer brokers? How have you found your ability to negotiate in some of those time sensitive or emotionally high charged moments in real estate that we love?
Yeah. I think in all aspects, whether, buying or selling, or even in the property management side, when I was there, we are often faced with different conflicts. And I look at conversations as they need to be had, whether they're good or bad. And that's kind of what we do is let's sit at the table. Let's figure out alternative methods if they're needed. Let's give kudos if we can. Otherwise, what are we going to do? I'm a firm believer that once we leave the table, there should be no hard feelings, regardless of what the decision is. And the way that we operate, and thankfully, like my buyers and my sellers have operated the same as me. We've had no real conflicts. There was one sale that I can really remember last year. That was a really rough sale. But the buyer's agent, I was representing the seller. The buyer's agent was like, it doesn't matter how rough the road is. Everyone agreed and everyone was happy. We got to closing. Everyone has benefited. And so that's just kind of the way that I operate is, if we have to have that conversation, I'm more than happy to. In the property management world, they are a little bit different conversations, but I still feel like they're just as rough.
Yeah.
And there's a lot more emotions in terms of like a renter versus, a buyer or a seller. But I just kind of use that throughout my entire life. I'm a dad as well. So I have those conversations with my teenage daughters. And I really feel that no conversation is good or bad, right? There's no wrong questions. And let's just figure that out.
Fantastic. Those are all my questions. Thank you.
Thank you.
Does anybody else have any questions?
I have one more. Tanner, okay, you mentioned Cherie was you said through this year or just kind of through, she doesn't really know, right?
That's correct. Yeah, she's looking to finish the high season. She has a few listings that she's representing right now. She's not looking to add any more listings or accept any more listings or representations. Her license is still valid through, I believe it actually is into 2027. But as of December, she's looking to fully retire.
Okay,
As of right
and
now, that's her decision right now.
sure.
That could
No,
change,
no,
but yeah.
I get that. Yeah, yeah. So obviously this isn't something you're doing, you need to do tomorrow, but you'll be able, it sounded also by your information that she's more than willing to work with you, and so you can, do you think she would, since she's still being licensed though, once she retires, your plan is then to transfer your principal broker's license to your other form a company, whatever you're going to do, right?
That is correct. Yeah. I'm looking, if this is to be approved, I'm looking to remain with Cherie B. Lander Real Estate until she retires. And then at that time, I would, if I was a principal broker, I would be hanging my license back to my original company.
Right. Okay. Okay. Thank you.
Thank you.
I have a couple of questions for you, Tanner.
Yeah.
Going back to the property management, is the property management division currently under or being managed in your current, where you're currently at? Or
No. The property management company
Yeah.
is being managed by Michael, two separate entities, and they have an office in the Dalles.
Okay, two totally different companies. So
That's
is your primary focus property management or real estate?
As of right now, my focus is real estate, is buying and selling.
Okay. So this property management company, are you an owner of the property management company, or did you just happen to do property management for a little while?
I did property management for a little while. Premium Property Management of the Gorge, I own, but I do not operate.
Who operates it?
Michael.
Michael, is Michael a licensed principal broker or property manager?
He's a licensed property manager.
Okay. So what are you looking for to expand in property management and real estate if you were to combine them both?
If I'm to combine them both, I think our main goal would be to offer buying, selling, and property management all in-house to our owners and to our tenants as well. My idea would be to offer just a seamless transition from a renter to a buyer, or from, an investor to a seller.
Does anybody else have any questions?
Yeah, I think I have one. It's a pretty simple one, just related more towards experience. Has your experience been mostly on the residential side, whether it's property management, sales, or do you have any commercial? And I'm saying that as a purely commercial broker myself. I'm wondering what diversity you might have between residential and commercial.
In terms of a broker, I do mainly residential. I have not sold any commercial. All residential. Yes.
All residential. And same on the property management side? No. Have you had any experience on that side?
Yeah, property management side is commercial, residential, and industrial.
Perfect. Thank you.
Thank you.
So maybe I didn't hear this before, but do you have any agents reporting? Will you have any agents reporting up under you in the residential sales?
If I become a principal broker while at Cherie B. Lander Real Estate, no, I will not. Also, if I go back to premium property management, I will not have anybody until I feel that I'm well adversed in that and able to properly manage somebody.
Okay.
Does anybody else have any questions?
So we're short a year and a half of the 3 years.
Sounds like Cherie's going to retire in December. So that gives him about 2 years. October of 2026 would be 2 years, I believe, for him.
That's correct.
And you have about 9 transactions under your belt since you started in the business.
9 for 2025. This year I've represented 3. Working on 1 right now. We're currently in pending stage.
And you said you have not supervised any agents under you.
As a
you-
broker, no.
No, I
As
know
a
that, but I'm saying,
Okay.
I'm sorry, I didn't ask the right question.
That's okay. And the property management side, I did manage Michael, and then we do have a staff, or I guess they do now. We did have a staff of unlicensed individuals that I managed.
Does anybody else have any other questions? Okay. So does anybody want to make a motion?
I make a motion to approve Ted Tanner's waiver.
I'll second.
Okay. So I will take a vote now on the motion to.
Dawn,
Oh, go
just
ahead.
ask for any further discussion and then take the
Oh,
vote.
sorry.
Yeah.
Any further discussion necessary? Okay.
Thanks.
So I will now take a vote on the motion to approve the waiver request. All those in favor, please physically raise your hand and hold. Okay, the motion passes. Is that it?
And then Dawn, someone from the agency will reach out to Tanner for next steps as well.
Luck.
Thank you guys. I really appreciate you. I do have one thing. In an email that I received from Darvel, it says that I may stay for the duration of the meeting. Is that still a possibility, or do I have to hang? I'm just curious on how you guys, I've never sat in one of these. I'm just curious how it operates.
Tanner, I would encourage you to join. You're certainly welcome to stay, and I encourage you to join maybe another meeting or visit our
Okay.
website. This is going to be a training for the board. That is also a curiosity. If you're interested, please stay. But
Okay.
it's not a standard meeting, and so it's really training for them. But please stay
And
if
the
you'd
next-
like.
And the next one, since it's in person at the Salem office, do you guys also offer that via Zoom? Like, could we chime in, or do I have to be present at that?
I believe, yeah, we'll be
No,
recording.
we'll do a Zoom as
Yeah.
well, right? Yeah, we'll record it so you can join in. Yeah.
Mhm.
Oh, okay. Then I will sit in on that one. Thank you guys. I really appreciate you.
All right, thank you, Tanner.
Thank you.
Dawn, just for clarity, we had a unanimous yes on that, right?
Yes.
Any nays? Okay, thank you.
Oh, I'm sorry. I should have asked for opposed.
I don't think anybody had their hand down, but I just
I
wanted
think
to
it was,
confirm.
yeah, I think everyone's hand was up.
Okay. So then we would be at new business.
Correct.
So this is Commissioner Strode.
Thank you, Chair Dirksen, and thanks for pitching in today. You rose to the occasion on last minute notice, so you're doing great. Thank you. So I just have one quick update. I'm not going to get into a big discussion today just because we have a long presentation as well with folks from the Oregon Government Ethics Commission. But at the spring governance meeting for Oregon Realtors, they brought up the topic of transaction coordinators, and I know at least one of you was in that meeting as well. And transaction coordinators are a business that's evolved over the last decade or so. The term itself does not exist in statute or rule. So as the business has evolved, folks that are engaged in that work are trying to operate within current statute and rule, but it's kind of silent on it. So what we've been asked to do is from the Business Issues Key Committee at Oregon Realtors, take this issue back to our board and then determine maybe potential next steps. Okay. So for a quick overview for folks that are not engaged in this business, transaction coordinators are individuals that help facilitate the transaction to close, but they're not the licensee who's negotiating the transaction itself. So they're doing, getting paperwork signed, things like that. The challenge becomes some of the individuals that are engaged in this business are licensees themselves. The business of transaction coordinator, however, is not necessarily a licensed activity. It's kind of in a quasi licensed area. So the confusion can be you have an individual who is doing this business on the side or as a part of their business. They're a licensee working for a different registered business name, doing transaction work for another company. The confusion can be a broker cannot work for multiple RBNs, but the work they are doing, they're saying, well, that's actually not brokerage activity. I'm seeing some head nodding because you all can understand the issue. So anyway, we want to research this. I think the first step we'll do is see what advice we may be able to give it as an agency within existing statute and rules. But I think this may evolve into more than that because again, the term itself is not defined anywhere anyway. So just a quick question to the board, again, not to open it up for full discussion today, that's future. Do you see the need for this as well?
Absolutely. We're
Okay.
living in a gray area.
Thank you,
and
Heidi. Yeah.
Absolutely, we need to.
Okay.
Yeah, I agree because I know a few agents that are with another company, but yet they're doing transactions for other companies.
Yeah.
They kind of put it out there like they're kind of floating around, and
Mhm.
it's for income. But
Yeah, it's an income opportunity, absolutely. Latasha, I think you had your hand
I
up
was
too.
just gonna say ditto.
Okay. Good. Well, we'll work on that. The other confusing part I've heard from lenders is that the transaction coordinator might be using their home brokerage account to send off emails to send to the lender, and then they're not even sure, well, who are you working for in
Who
this
are you?
transaction?
Yeah, we've
Yeah,
had
who
that
are you?
happen.
Who are you working for?
Yeah.
So, okay. Well, that's all I wanted to surface for today, just to get what appears to be consensus that this is a worthwhile issue to address.
Yeah.
And then we'll come back. We'll make it a topic at the August meeting. I think it'll be nice. We'll be in person in the same room. At that point, we'll talk some more about it then. Thank you. That's all I had, Chair Dirksen. Yes.
All right, thank you, Commissioner Strode.
Mhm.
So it looks like the next thing on our agenda is our board advice or action, and it looks like we
Yes.
have a training for today.
Yes. So thank you for that. So we have guest speakers from the Oregon Government Ethics Commission who will be taking the board through training. This is required training we do on a periodic basis. So I see we've got multiple folks. So I'm just going to let you introduce who's here and let you take over the meeting for the time being. So thank you.
Perfect. Thank you so much. Let me go ahead and also share my screen while we do that. Okay, make sure it's shared. Second. There we go. All right. So thank you so much for having us today. My name is Lex. I'm a trainer with the Oregon Government Ethics Commission. We call it OGA. It's a lot easier to say over and over. I also have Angela with me here today. She will be doing the second half of the training. We'll be switching it up so you can hear a couple different voices. Helps not get so bored with a longer training. And we also have Stephanie here today. She is our training coordinator. She will just be observing the training and then, jumping in if we do have any questions. So the first thing, we will be doing some polling during the training, helps keep it interactive and just, checks your knowledge on what you already know, and then we'll be able to retest as we go throughout. So if you do have a cell phone or, if you're on your laptop, you can either scan the QR code that's showing, or you can go to ttpoll.com, and then you'll enter the session ID LTOGEC. From there, it will ask for your name and your email. You can choose to give your board email or your personal email. Doesn't matter to us. It's just so we can send you a follow-up email with all the resources we'll talk about. We do have some handouts, a guide for public officials, things that'll help make sure you're complying with the law and all the statutes we'll be talking about today. And then once you're logged in, it will just ask you a first icebreaker question of just chocolate ice cream is better than vanilla. You can answer true, A for true or B for false. There is no right or wrong answer. I know some people think there's a wrong or right answer, but that is a subjective question. So, but we'll go ahead, give a few minutes just to make sure everyone gets logged in. And I think we should have 7 or 8. How many today? And then if anyone's having technical difficulties, just let us know. Usually it works pretty smoothly, but technical difficulties can happen. So,
And there isn't a
and
send, it's just you lit your answer, right?
yeah, that was the next thing I was about to go over. That there's not a submit or anything. It just highlights the one you select.
Okay.
Yes. It's not the most intuitive user face. I will say that is something that trips people up. So yes, thank you for clarifying on that. Okay, perfect. I think we have mostly everyone. All right. So yeah, that'll just be the polling we'll be using throughout. We'll do a pre-test in just a few minutes. But let's go ahead and go over kind of some basic information now that it looks like everyone is logged in. Let's see. Okay. So at the Oregon Government Ethics Commission, again, OGEC for short, we're here to assist public officials with complying with government ethics law. Education is one of our highest priorities. That's why we do trainings like this, give advice, all things like that. As a trainer, my job is helping public officials navigate the nuances of the law through trainings and staff advice. And really the purpose of today's training is to increase your understanding of how ethics law applies to you as a public official. So let's go ahead, and one of the questions we like to first ask is, what do you think of when you hear government ethics? And you can actually type it in on the device you're using, or if you want to go ahead and just unmute, let us know, whichever. If you type it in, it will appear on the screen. So just know that. Honesty. I like that answer. Let's see what else we get. Vital. Yeah, that's a good one. Compliance. Yes, definitely. Yeah, another vital. I agree. Fair, acting honest and professional. Yeah, these are good ones. I don't always get good answers on this, so it is good to see that we are committed to that. And yeah, transparency. Transparency is a big one. Okay, good. I like seeing this. This means we have a good idea of what ethics means in the terms or the context of ethics law, because ethics themselves, that itself is a pretty big word, can mean a lot of broad things. But as we talk about ethics law, we are specifically talking about the statutes and what they mean, a lot of times talking about like financial connections. And you'll kind of see the scope of that as we talk about the provisions today. So when we are talking about ethics law, the reason we're here today is that these provisions in Oregon government ethics law really do restrict some of our choices, decisions, and actions as public officials. These restrictions on us as public officials are different than the restrictions on private citizens, right? Because our service as a public official is a service in a public office, it's a public trust. And basically the statutes in ethics law, chapter 244, were enacted to provide a safeguard for that trust. That means as public officials, we have to make personal judgments when it comes to matters like our position for financial gain, if we can accept a gift, or if we need to disclose a conflict of interest. And if we do fail to comply with a statute, that violation can't be dismissed by putting it on our public body, right? It is actually our personal responsibility to, one, know the statutes of ethics law, and then two, comply with them to make sure that we are safeguarding that public trust. So that's what we're really focusing on today. And then I do like to give a little bit of background on OGEC, why we're the ones here. That helps give us a little bit more information, because Oregon Government Ethics Commission began in 1974. That was when ethics law was enacted by voters. That was Watergate era. So public trust in government wasn't the highest. We can kind of understand why we wanted some of these laws to make sure there was that transparency and that compliance with public trust. The OGEC, we are formulated to regulate government ethics law. We have a commission that's made up of 9 volunteer members. They're appointed by the governor and the legislative assembly, and then confirmed by a vote of the Senate. And then we have our agency staff of about 15 that helps enforce the laws within our jurisdiction. And so we obviously have ethics law. That's what we'll be talking about today. That's things, conflicts of interest, use of office, nepotism, gifts. But we also have lobby law. So that's where lobbyists have to register and quarterly report their expenditures. And then public meetings law. This one is a little bit newer, or well, parts of it. We had some of it since the 90s, some of it just until 2023, but we also have jurisdiction over that now. So if you ever need any advice or information on these laws, that is what is within OGEC's jurisdiction. Now, a few things about today's training. Just one, that the information provided today is an overview of ethics law. So it shouldn't be used as a substitute for reviewing the specific statutes and rules themselves. That is always the first place to start if you do have a question on ethics law. And in that same vein, this information is not designed to be a substitute for legal advice, and it should not be viewed as constituting legal advice. Every situation has its own set of details, and often there are other laws or regulations affecting a situation, that's not within our jurisdiction at OGEC. But if you do ever have a question about ethics law, please reach out to us. We are available Monday through Friday, 8 to 5, and we are here to help with ethics law. And then during this training itself, if you have any questions, we will have a question section or question slide at the end of each section. So if you do want to hold your questions till then, we can verbally ask them. Or if you want to use the chat, you can at any time put your question in the chat there. Angela will be watching it during the first half, and then when we switch, I'll be watching it during the second half. But let's go ahead and get started then. So again, today we are focusing on ethics law that is contained in ORS Chapter 244, and then we'll also be looking at some of the rules in Chapter 199. So the things that are contained in ORS Chapter 244, conflicts of interest. We're talking about what that is, how we disclose one. Prohibited use of office, what financial benefits are prohibited, what's allowed to us as a public official. That also includes private and subsequent employment. So how the laws apply to our income producing activities and the limits on any private and subsequent employment. And then we'll briefly go over nepotism, which is the employment of relatives and household members. And we'll end on gifts. What is considered a gift and what are the limits on the gifts you can accept? So what we're really focusing on with ethics law is addressing the financial impact of our decisions as public officials on ourselves and those connected to us by law. But really our goal for today's session is that you will be able to identify these 5 areas of the law and know, if something arises, hey, this is something to do with ethics law. Either I should look at the statutes, or if I have a question and haven't been able to walk through it myself, I can contact OGEC because this is something I need to comply with. All right, so what we first do, like I said, there is a little pre-test. We just want to see what you already know about ethics law. These answers are all anonymous. If you don't know, take your best guess. We are going to answer 1 question per section, and then we will be retesting on them later after each section. We'll be using that device, whether you're using your cell phone or your laptop, and using that ttpoll.com. So our first question here. Your board is voting on whether or not to change the process for when real estate brokers want to request experience waivers for licensing. That's a very similar agenda item, right? Your sibling is currently a real estate agent working with their agency to become a broker. Have a conflict of interest when discussing this topic. So the question here is, as a board member, do you have a conflict of interest when discussing this topic? Your answers are A, yes, I have a potential conflict of interest. I need to state the conflict of interest for the record before discussing this matter at every meeting. B, yes, I have a potential conflict of interest. I need to disclose the nature of my conflict to my supervisor in writing. C, yes, I have an actual conflict of interest and I cannot participate in any discussion. Or D, no, I do not have a conflict of interest and I do not need to take any action. All right. Go forward to the next question. Okay, this next one. You're planning an event for your family this summer. you need a location, and remember that the board has access to a great private room. You ask staff if you can borrow the room for a few hours for your event without cost. They say yes. You have violated government ethics law. A for true, B for false. Okay. Now, our question here is, in addition to being a board member, you also own your own business. Can you promote your business in the following situations? So, are you able to promote your business in the following situations? This is a choose all that apply, so you can choose multiple here. We have A, in your personal LinkedIn account, B, in the agency break room after a board meeting, C, at a conference where you've been invited to be a speaker as a board member, or D, during board meetings. All right. And one more question here, and this one is also choose all that apply. You are sent to a conference as a board member. At the conference, you win a raffle for a tablet. What questions do you need to ask yourself to determine if you can accept that tablet? And so again, choose all that apply. We have A, who is the gift offered to? B, who else has accepted the gift? C, who is the source of the gift? D, is anyone else offering the gift? Does the source have a legislative or administrative interest in what you do? And F, what is the value of the gift? Oh, we ate that time. Okay, perfect. All right, thank you for taking the time to answer those. So with that, we won't go over the correct answers quite yet. When we go ahead and retest after each section on one of those, we will then go over the correct answers together. So we have a high-level overview of what government ethics law involves and the commission's jurisdiction. But let's first talk about who government ethics law applies to, because that's important. So first group of people is public officials. But who are considered public officials? By the law, you are a public official if you serve the state of Oregon. That includes any city, county, special district, or any other public body. And this is regardless of whether you are compensated for your service or not. So it's estimated that there are 260,000 public officials in the state of Oregon, many of whom are not paid for their service. So the definition would include public employees, elected officials, board members, councils and commission members, as well as volunteers. So other examples, police officers, school teachers, state employees, city council members, firefighters, school board members, even volunteers at public libraries. They are all considered public officials because, again, they're serving the state of Oregon. So all of us here, public officials. And this is important because we are the ones, whether we are an employee or volunteer, we are serving the state of Oregon, and we are therefore responsible for complying with Oregon government ethics law. So we are responsible for knowing the law and complying with it. And I also like calling out all those different positions because sometimes we realize we may be a public official in one area, but not have realized maybe we were doing, like I said, that volunteering at a public library, may not have realized we were a public official in that role as well. So it is kind of important to look at the different ways we can be a public official. But beyond that, the law also applies to public officials' relatives. So who is considered a relative under the statute? Now, the statute defines a relative to include your spouse, your children and stepchildren, your daughters and sons-in-law, your parents and step-parents, your siblings and step-siblings, and then your spouse's family, so their children, their parents, and their siblings. Now, you might be looking at that list and thinking, there are some relatives missing from there, right? And yeah, you would notice that there aren't any grandparents, any grandchildren, nieces, nephews, aunts, uncles, cousins. Those family members are not defined as relatives per the statute. So only these ones listed are defined as relatives. And there are also some financial connections that can make someone a relative under the law. So if there is anyone you have a support obligation to, or anyone that receives benefits of your employment as a public official, or anyone from whom you receive a benefit of the employment, they would also be considered a relative under ethics law. Now, the third group of people that are included under ethics law is any member of a public official's household. And this one's pretty easy. A member of our household is any person who lives in our home. So if anyone who lives in your home, they would be considered a household member. That could be grandparents, foster children, exchange students, significant others, cousins, roommates, friends. Again, if they live in your home, they're going to be considered a household member under ethics law. And then the last one is associated businesses, because the law requires you to be aware of how you're connected to businesses. So first, we need to know what is considered a business. And it's the usual definition here. It's defined as any legal entity operated for economic gain. So corporations, partnerships, proprietorships, firms, enterprises, franchises, associations, organizations, self-employment, those would all be considered businesses. And again, anything created and operated for economic gain, going to fit that legal definition. So once we know something is a business, though, we then need to figure out if it's associated to us, our relatives, or our household members. And to do that, we look at the two categories of businesses. First, there are private businesses or closely held corporations, or publicly held corporations, where the stock is publicly sold and owned. So for private businesses, you have to meet a few criteria. First is if you, your relative or household member, is a director, employee, officer, owner, or agent of that business. If you meet that, then you are associated to that private business. For public businesses or publicly held corporations, a little bit different because it's only if you, your relative or household member is an officer or director of that business. So we can see the differences between those two criteria there. And there's one other additional criteria, and that's if you, your relative or household member owns stock, equity interest, stock options, or debt instruments of $1,000 or more in that private business at any point in the preceding calendar year. So for private businesses, it's $1,000. For publicly held corporations, same thing if we own the stock, equity interest, stock options, or debt instruments, but the amount changes to $100,000. So we can see that they're very similar in the criteria, but there are slight changes where we have to hold these specific positions or a much larger amount. And so an example here is, if you had a sibling that worked for a minute worked at a local hardware store. It's an independent business, private business. Let's say your sibling, your sister is a department manager there. Well, that's an employee of a private business. That's a business that she is associated with. But let's say she starts looking for another job and she gets hired as a manager at the Lowe's. Well, Lowe's is a publicly held corporation. It's owned, its stock is publicly owned and traded. So with that, she's now a manager at Lowe's. Is that an officer or director position though? No, she's not an officer or director. So she is not associated with Lowe's. But if she ever gets to the point where she owns stock or equity interest, stock options, debt instruments, any of those four to $100,000, then Lowe's would be an associated business. So that's where we can see the difference between those private business and the publicly held business. And there is one other thing with associated businesses. There are certain public officials that have to file an annual statement of economic interest. It's not a lot out of the 260,000. It's about roughly 6,000 per year. If you do ever have to fill out an SEI, that's the acronym we use here. If you list any business as a source of income on that report, they would automatically be an associated business, even if they don't match the other criteria. But if you don't have to fill out an SEI, don't worry about this. We do just like to mention it because sometimes public officials do, especially if they have multiple roles. So the other thing to know with businesses is that public business or business is not a public body. So if you are connected to like a city, county, special district, anything like that, that is not going to be considered a business. Just by definition, it's not. And then if you are connected to a 501c, so a nonprofit corporation has to be tax exempt 501c. If you, your relatives, or household members are associated as a member, a board director, or in an unpaid position, that does not meet the definition of a business. 501cs can get a little bit complicated. So if you're ever unsure on that one, that's a great time to either, if your public body offers legal counsel, reach out to them or to reach out to us for advice. But if you do meet those, you're a member, board director, or unpaid position, it would not be considered a business by definition in the statute. All right, so let's go ahead. We're going to use polling here just to check in and see how we feel on the information on those definitions. Just say your cousin is included in the law's definition of a relative. We have A for true, B for false here. I think we had 8 last time, so I'll leave it open a little longer. Okay, well, let's see. Yeah, there we go. Yes, this one is false. Remember, the cousin is not included in the definition of the relative. The only exception would be if they met one of those 3 financial obligations we talked about, but otherwise they are not included in that. All right, how about this one? A volunteer firefighter is a public official. A for true, B for false. What do we think? All right, okay. Again, even if they're volunteering, remember, a volunteer firefighter would still be serving the state of Oregon. So they would be a public official even if they're not being compensated. I did get a question once that someone was like, what if they're a vigilante firefighter? Well, I guess in that case, they would not be a public official. But in this one, we are just saying a normal volunteer firefighter that is signing up to serve the state of Oregon. So they would be a public official. All right, this last one, we're actually gonna, yeah, okay, we'll do this one. So you serve as a director on the board of a 501c nonprofit. The nonprofit is a business with which you are associated with. A for true or B for false. All right, let's see this one. All right, so this one is false. Because remember, if we're serving as on the director on the board, so we're a board director of the 501c nonprofit, that is that situation where that nonprofit does not meet the definition of a business. So that would mean it doesn't meet the definition of a business. It can't be a business we're associated with. But again, those ones do get complicated, so completely understand with that. And you can always be on the side of caution of, yes, that's something directed with me or connected to me. Talk a little bit more about that with conflicts, but it would not meet the definition of a business there. So, all right. Before we move on to conflicts of interest, then, any questions on definitions?
A question.
All right. Oh yeah, go ahead.
Okay, so you mentioned that a relative is anyone or a relative that receives benefits from your employment or vice versa would be considered associated with you, right? Does it have to be associated with your public employment, or for our board members, they may receive benefit, a family member may receive benefits that's not related to their role as board member, but from their private employment?
Yes. So the first part is anyone who receives benefit from your employment as a public official. So that part is your employment as a public official. And then the second part is if you are receiving benefits from someone from their employment. So the second part, if you're receiving benefits from someone employment, it doesn't have to be them as a public official because you're the public official. But the first part, when they're receiving benefits from your employment and you're the public official, it has to be your employment as a public official. So if they're receiving benefits from their private employment, that would not count there. We are specifically looking at benefits of public official employment.
Got it. So our board members who are public officials, but compensated only with a stipend and don't receive benefits, if they have someone that falls into this category that isn't otherwise associated to them, that person is not linked in this way.
Correct. Yes. If they're
Okay.
receiving benefits from private employment, they wouldn't qualify under that. We are just looking at benefits from public official employment.
Thank you.
You're welcome.
I had a question too.
Mhm.
So you mentioned the 501Cs. So does that include the entire list of different types of Cs, like 501c3, 501c6, stuff like that?
Yes.
Okay,
Mhm.
all right, the whole list.
Yeah,
Okay, great.
Yep. There are other statutes that will specifically call out a C, like C3 and things, but when we are looking at business definitions, it is 501c. It leaves the number portion open.
Great,
So,
thank you.
yeah, great question. Awesome. Okay. I'm not seeing any other questions, so let's go ahead. Now we can talk, now that we know who the law applies to, we can start looking at some of the areas of it, starting with conflicts of interest. So conflicts of interest has two types, an actual conflict of interest and a potential conflict of interest. And we're going to start with an actual conflict, usually a little bit easier to identify, and it comes first alphabetically. So an actual conflict of interest is any action, decision, or recommendation made by you while in the capacity as a public official, which would be to the private financial benefit or detriment of yourself as a public official, your relatives or your household member, or any business that you or your relative or household member is associated with. Kind of a long definition there. But what this really means is that any action you take would with certainty create a financial effect. So I'm going to use an example from one of the questions we looked at earlier. So if you did have a real estate broker applying for that experience waiver for their license, and then let's say that this person applying is actually a roommate of yours. Well, your action of voting on issuing that waiver is an official action. And that action would either support them being able to get that license with that waiver or not, which would have a financial impact on what they can do with the future, right? And that financial impact is going to be on your roommate, who is a household member. So we have fit the three requirements for a conflict of interest. That makes this an actual conflict of interest. Now let's look at potential conflicts of interest because it's very similar here. So it's any action, decision, or recommendation made by you in the capacity as a public official, which could be to the private financial benefit or detriment of yourself as a public official, your relatives, your household member, or any business that you or a relative or household member is associated with. So basically the exact same definition from before, we took would and changed it to could, because the financial impact of our action is possible, but not certain. So a scenario here for this one, let's say instead the board is discussing revisions for continuing education requirements. You're not at the point of deciding specific revisions, just whether you need to make revisions or not this specific session. And you actually have a parent that works as a continuing education provider in the real estate field. Well, again, we have the discussing and potentially voting on whether or not to make revisions as your official action. And that action could have a financial impact. If you decide revisions need to be made, it could lead to substantial changes, which continuing education providers could be looking at spending a lot of time and effort to update the materials and courses. Your vote could also mean that, you choose not to make revisions, right? You decide no. So maybe we're looking at not having to make changes and no financial impact there. But there's a potential impact. And again, it's our parent who is a relative. They could be the ones that have this possible financial impact. So we have an official action of us voting on this. There's that potential financial impact. We're not exactly certain of it yet, but there's a possibility, and it would be on our parent who's a relative. So again, we have a potential conflict of interest here. And in both of these scenarios and both of these definitions, when we're talking about conflicts of interest, I hope you noticed I was looking for three things. And those are, one, you as a public official need to be taking an official action. That could be a vote, a decision, recommendation, other kind of action there. And then that action is going to result or could result in some kind of financial impact. Another thing here is it could be a benefit or detriment. That is something that's sometimes missed with conflicts of interest. They can also be a bad financial thing. It doesn't just have to be good financial things. And then the last one is that that financial impact could or would be on certain people. It's going to be yourself, your relatives, your household members, or any businesses associated with those same people. And I will also point out, if you've had this training from us before, I know you said you've taken ethics training a couple of times, household members was just added. They used to not be included in conflicts of interest. It was added this year. So if you're like, this sounds a little bit different, that's because household members was added this year. So now conflicts of interest also apply to them. But then whether potential or actual, once you realize you have a conflict, you need to comply with the appropriate disclosure methods and go forth there. So let's talk about that. We realize we have a conflict of interest now based on the definition. What do we actually do once we recognize we have a conflict? And the law actually has different disclosure methods depending on what type of public official you are. So board and commission members have specific types of disclosure, employees and appointed officials have another disclosure method, and then judges and legislative assembly members also have their own. We're going to focus mostly on board and commission members. I am also briefly going to go over employees just so the staff here are aware. And then if you ever, are just realizing if you hear anything or have a staff talking about conflict of interest, you just also are aware of what that disclosure method looks like. So if an employee ever has a conflict of interest, whether it's potential or actual, what they have to do is provide written notice to their appointing authority, typically their supervisor who hired them, describing the conflict, asking for it to be disposed of, and they have to do this every time that conflict comes up. So that's what an employee will do. In that case, their supervisor or the appointing authority will then also respond to them, and they will either assign someone else to handle the task or give them specific instructions. So for any staff in the room, or if you ever have staff talking about a conflict of interest and you hear them being like, that doesn't sound like the right disclosure method, that's because employees and appointed officials have to do this written method. For boards and commission members and elected officials, it is different because when you have a potential or actual conflict of interest, you have to make a public disclosure. So for potential conflicts of interest, that means you're going to publicly announce that you have a conflict of interest. That would be at the meeting you're discussing that agenda item, saying, hey, I have a conflict of interest because of XYZ. You do have to give a little bit of information, disclose the nature of your conflict, right? And once you make that public announcement with your potential conflict, you can continue to act. So that means you can discuss, you can debate, you can vote on the item. It's just really important that you make that public disclosure before you act. With actual conflicts of interest, it's a little bit different. We still make that public disclosure. Again, I have an actual conflict of interest because of XYZ, right? Giving the little bit more details to describe the nature of the conflict. But once we make that public disclosure for an actual conflict of interest, we can no longer act. So we cannot participate in any discussion, any debate, or any voting. And what's really important for both potential and actual conflicts is that we make these disclosures every time the conflict arises. So if it is an agenda item that's happening at multiple meetings, we need to make this disclosure of our conflict every single meeting that appears. Not just the first time it appears and thinking we're good, because again, this is to safeguard that public trust. We might have public appearing at different meetings, not, they weren't there for the first one. We need to make sure that we have made that public disclosure every time. And then the other part of this too, if you ever have an executive session, knowing again that this is a public disclosure. So if there's an executive session agenda item that you have a conflict of interest on, making sure you make that public disclosure of your conflict in public session before you go to executive session. So biggest thing there, making sure we have that public disclosure before we do anything else and making sure it happens every time the agenda item comes up. With potential conflicts, we can continue to act. With actual conflicts, we cannot continue to act. Now, there are some exceptions. So One of the exceptions is with that voting rule with the actual conflicts. If multiple members have an actual conflict, you as a public official can vote if your vote is needed to meet the minimum number of votes required to take an action. You still can't participate in any discussion or debate on the matter, and you'll still need to make your public announcement of your actual conflict. So again, make that public announcement, can't discuss or debate, but then you could vote. An example of this would be, typically you see this like with a lot of smaller boards. Let's say we had a 5-member board, and so their quorum is 3. They need 3 votes for board action. Well, at the time of meeting, 1 seat is vacant, another member is absent, and 1 member has an actual conflict of interest. So the other 2 can vote, but this 3rd member, which this 3rd vote is needed, also has an actual conflict of interest. Typically, they wouldn't be able to vote, but because of this exception, they can vote. Again, they need to make the public announcement of their conflict. They can't discuss or debate, but they can vote to meet that minimum vote requirement. So there's one exception there. Now, when you do give a notice of an actual or potential conflict, the public body that you serve is going to record that conflict in the official record. They're required to. For employees, that's going to be in their personnel record. For board members, this is where it's going to be recorded in your video recordings of meetings or in your minutes. If you're doing both, it should be recorded in both. But just making sure that there is a record of your conflict of interest disclosure. That is important. All right, so that is our section on conflicts of interest. Let's go ahead and take a look at that conflict of interest question again. We'll test on it and see how it did. So your board is voting again on whether or not to change the process for when real estate brokers want to request experience waivers for licensing. Your sibling is currently a real estate agent working with their agency to become a broker. Do you have a conflict of interest when discussing this topic? And so, as a board member...
Can I make a suggestion here once?
Yeah.
Just a minor revision in the question. If you could back up a slide.
No problem.
I think the situation here would be a principal broker, not a broker.
Oh, yeah.
Yes.
Principal. Thank you. Yeah.
Because that's what they vote on. Yes. So just...
Yes.
I meant to say
thank
earlier.
You.
Yeah. So principal broker. Yeah.
Yes. Thank you so much. And that is, yes, I'm not an expert in real estate, principal, all of that, just the training, the ethics law. So thank you for calling that out.
Totally.
Yes. So principal broker, apologize for that. Yes. So yeah. And just you're voting on whether or not to change the process for when they want to request experience waivers on this. Okay. And your sibling is currently that real estate agency working to become a principal broker. Do you have a conflict of interest when discussing this topic? So as a board member, do you have a conflict of interest? And our options here. A, yes, I have a potential conflict of interest. I need to state the conflict of interest for the record before discussing this matter at every meeting. B, yes, I have a potential conflict of interest. I need to disclose the nature of my conflict to my supervisor in writing. C, yes, I have an actual conflict of interest and I cannot participate in any discussions. Or D, no, I do not have a conflict of interest and I do not need to take any action.
And again, this would be somebody who's coming up before the board for seeking a waiver. So that narrowly defined scenario there. Yeah.
Yes. And this again, this is for, you are talking about changing the requirements for someone seeking a waiver. This isn't a person seeking a waiver quite yet.
Thanks for letting me chime in.
Yeah, definitely. Thank you. Okay, I see we have 8. Let's go ahead and see. All right, yes, so we have a split here. Okay, so and this is why I was trying to clarify on that. So this one is a potential conflict of interest here. And it's because, like I was saying, we are talking about just changing the requirements of the waiver, not necessarily approving a waiver yet. So at this point, we have that potential because we are just discussing changing the requirements. There could be a financial impact to our sibling. We haven't actually discussed what those requirements are. They are not applying for that waiver quite, like we don't know if they will need to, right? So we are in a potential situation because there's a chance for that financial impact, but it's not certain right now. So this is a potential conflict of interest. That means we need to state the conflict of interest for the record, but then we can continue discussing debating and even voting on the matter. So good job. That one was a little confusing. I will say probably not the best question, but kind of that's how we have to start thinking about these situations. Where are we at? What is the possibility of that financial impact?
Can I add another piece of information here?
Mhm.
Oh, you're on questions anyway. Good. So this goes back to early days when I first joined the agency, and on the previous slide that she brought up really illustrates the confusion sometimes. We had a board member who's had a broker in their office looking for the waiver, and he did disclose that there a potential conflict of interest, but then went on to engage in like a personal endorsement for the applicant, which is not, as you saw on the previous slide, don't engage in the conversation if there was a conflict of interest. So he made a point of disclosing, I think he said it was actually a conflict of interest, right, Anna? It goes back years. It doesn't even matter at this point. It's just a good example of making sure that if you are disclosing it, then also don't personally then endorse the person because you've disclosed a conflict of interest. So I think the one thing I wasn't clear of, and it's a good lesson here, is they can still vote. They just have to disclose it.
Yep, if it is that potential, if it's potential conflict, once you make that disclosure, you are still able to engage, debate, discussing, and voting. It's only if it's that actual conflict where you are certainly going to have that financial impact and it's on those specific people, that's where you can have none of those actions. So
Yeah. So great example that we actually may occur if you ever get somebody in your office who's applying for a waiver. This situation applies.
And that would be an actual in that case, right? If they're within your line of supervision and they're going to another license level, it's potential in that it hasn't necessarily yet realized sales, but it is providing them more breadth on their ability within the license structure, right? Like it expands their authority and ability, and you're supervising that person. I mean, it's a bit of a gray area, so I guess I'm more asking than stating.
yeah, I mean, just from those details, it does sound, because again, we have to remember the specific people are ourselves, our relatives, our household members, or any business associated with any of us. So if it's someone that works with us and it's an employee, then and it's going to have a financial impact on them, that would be a business associate, right? Because that's also they're an employee of the same business that we are. That is a business associated with us, so it's going to have a financial impact. So yes, that would be an actual conflict.
An actual.
Mm-hmm.
Despite the fact that no sales have yet occurred, they just would likely in the future, it's still an actual conflict.
Yeah, if we're talking about getting, again, it depends on the decision. This is where I will say if you do ever have a specific thing happening and you're unsure, that is a great thing to reach out to us for advice, because then we have all those details and you can give us a phone call and we can just go over it right there before it happens. Angela will talk about that a little bit towards the end too. But yes, if you are like talking about we are going to approve or deny this waiver, that's going to have a certain impact on, because if you approve that waiver, they can continue with their license and we'll have sales from it, right? If you deny that waiver, that causes a problem. They're probably not going to have sales. So we could see that having a negative financial impact. So that is a certain financial impact. They're an employee of the business that you're associated with. That's a financial impact on the business you're associated with. That would be an actual conflict. So that's where you would see those two criteria for a conflict. Does that make sense?
Yes,
Yeah.
thank you.
And the key here too is if it ever comes up, we have staff resources like our fine folks on the call to help us guide us through that if it ever happens in your own personal case.
Yes, definitely. Great questions. Okay, and I'm actually going to go ahead and stop sharing for a second because Angela is going to jump on now and be giving the rest of the presentation. So give us just a second.
Hello, everyone. Bear with me while I share. Okay. And hopefully you can see that and hear me okay. So thank you for having us today. I did just want to throw in some personal information. My first real job was working for a top producing real estate agent. So I have a teeny tiny bit of experience. I also have a family member who is a current realtor. So I support and appreciate what all of you do. And thank you, Lex, for getting us to this point in the presentation. So I'm going to take us through to the end, and now we're going to look at prohibited use of office or position provisions. So the provisions in Chapter 244 address allowable and prohibited financial gains for public officials. And so what is prohibited use of official position or office? Well, when we talk about those terms, we use position and office interchangeably. But as a public official, you may not use or attempt to use your official position to obtain financial gain or avoid financial detriment for yourself, a relative, a member of your household, or any business with which you, a relative or household member, is associated if the financial gain or avoidance of financial detriment or attempt to use your official position, I messed myself up there. If the financial gain or avoidance of financial detriment would not otherwise be available, but for your holding of the official position. See, that's a lot of words to say. So I got stuck on that, but all of that to say, basically you as a public official may not use or attempt to use your official position to obtain financial gain or avoid financial detriment. Coming back to some examples for you. So the example of the actual conflict of interest where you were issuing an experience waiver for our roommate who was applying for the real estate broker license. So this is also an example of a use of office because voting to give your household member the waiver, which would be avoiding a financial detriment of getting the experience otherwise for them, is something that we're only able to do because of our position. Now, it goes to show how often the scenarios where conflicts of interest and use of office are intertwined, and you'll see that. Some other common examples of prohibited use of office would be, let's say somebody using a government vehicle for their personal use, signing a contract between the board and your spouse's employer, or maybe submitting hours that you didn't actually work for, let's say for the stipend, things of that nature. Now, there's a pretty easy way or key way to determine whether something is allowed by this law or not. And that's just simply to ask yourself, do I only have this opportunity because I'm a public official? If the answer is yes, then the action is probably prohibited by ORS 244.040. But the flip side to that is if the opportunity is available to the general public, then the benefit may be allowed. So as an example, let's say there's a public works employee that has the opportunity to use the department's leaf blower over the weekend at their own house. They're going to need to ask themselves, hey, do I only have this opportunity because I'm a public employee, a public official? If everybody in the community is not allowed to use this leaf blower, and it's only available to this public official because of the work they do for that department, then yes, this is an opportunity that is only available to them because they're a public official. So borrowing that leaf blower would be a violation of the law. Now, conversely, if we have a librarian that has the opportunity to print a 10-page document at the library, if they ask themselves the same question, hey, do I only have this opportunity because I'm a public official? Well, if the library is open to the public and anybody can come in and use those computers to print 10 pages for free, then no, this is not an opportunity that's only available to them as a public official and would not be a violation of the law. Now, there are several circumstances the law identifies where a public official may use their position to accept financial benefits and not be in violation of the law. And the first, and I would argue most important, would be official compensation. So public officials may accept any financial benefits that are identified by the public body they serve as their official compensation package. So if the public body formally adopts a policy or they have an employment agreement or union contract that permits benefits like health insurance, paid allowances like childcare, even salary, then that would be an exception to prohibited use of office. Another common one would be reimbursement of expenses. So payments from our public body that we receive as reimbursement for expenses that we personally pay while conducting official business. And I'll note that reimbursements must comply with applicable laws and policies. Things like parking fees, or let's say you register for an event, or mileage, meals, things of that nature would be examples of things you might be reimbursed for. So one thing we also like to note in this section that kind of gets into this area of law is if your public policy, or excuse me, if your public body has a policy regarding reward points that you receive from purchasing with your personal cards, then it may be permitted. And I mean, almost every card, that exists these days has some sort of reward associated with it. If there are no policies in place and you use your personal card and get personal benefits or reward points for that, that could be considered a use of office violation. So just like to give everybody a heads up on that. All right, another exception is honorarium. So this is a payment or something of economic value that's given to a public official in exchange for providing a service. So services can be things like speeches or presentations that you give at an event. And to qualify as an honorarium, there has been no set price in exchange for your services. So you're not agreeing ahead of time, hey, I'm getting a certain amount of money for this. Honorarium is usually things like certificates, plaques, could be a commemorative token, even things like gift cards, chocolates, flowers, something of value. But if the services are in connection to your official duties, then you can accept honorarium with a value of $50 or less under this exception. Okay, another one is awards for professional achievement. So we can accept this type of award if we have not solicited for it, and the award is offered to recognize a professional achievement. These should not be confused with awards of appreciation, honorarium, or gifts. We'll talk about a little bit later. Those things that are allowed or restricted by other provisions of ORS Chapter 244. Now, awards for professional achievement are best illustrated by awards that denote a national or international recognition of a public official's achievement, like receipt of the Nobel Prize. These awards may also be offered by public or private organizations in the state that are meant to recognize a public official's distinguished career. One big example is Oregon Teacher of the Year Award that the Oregon Department of Education issues. And professional achievements recognized may be identified as a single accomplishment, or it could be an accomplishment achieved during a year or at the end of a public official's career upon their retirement. Now, contributions to a legal expense trust fund is another exception, and there are provisions in the law that allow public officials to establish a legal expense trust fund to assist in paying legal expenses incurred from legal proceedings that relate to the course of their official duties. So this is something that's complicated, and it has to be established with the Oregon Government Ethics Commission. So this is a please contact us for more information if something comes up where you think you might fall under this exception. Now, a new exception, pretty recent in the law, is one that now allows public officials to receive compensation from any post-secondary institution for teaching courses at the institution. So this means that it is not a prohibited use of office if a post-secondary institution hires a public official to teach courses because of their experience as a public official. So some examples would be allowing judges to teach at law schools, healthcare providers, doctors, et cetera, teaching at OHSU in their area of expertise, or even like an elementary school teacher teaching a course in education. So just to recap, public officials cannot use their position to gain financial benefit or avoid financial detriment if that opportunity would not be available but for their holding of that public position. So this means that public officials can't use public money, equipment, or other resources for personal activities, even if the result is not a cost for the public body. All right, so We are going to do a knowledge check, like Lex has been doing with you up to this point. Retesting on some of those questions. All right, so here we go again. So you are planning an event for your family this summer. You need a location, and remember the board has access to a great private room. You ask staff if you can borrow the room for a few hours for your event without cost. They say yes. You have violated government ethics law, true or false? And we are not going to see the poll populate that little oval because we're doing something different because we're in two different places, but I'm going to assume everybody's answered the question.
You're good to move forward now.
Okay, thank you, Lex. All right, and the answer to that question is true. So you would not have that opportunity, but for your holding of that position on the board. So that would actually be a violation of prohibited use of office. Okay, any questions on what we just covered? And I'm not seeing any. Okay, and Lex is also watching in the chat if you type anything in there. Okay, so let's talk about private employment and how it relates to the use of office and position provisions. So Oregon government ethics law does not prohibit us from working for a private employer or owning a private business while continuing employment with or holding a position with a public body. And as we already discussed, many public officials are volunteers, meaning there's little or no compensation for that position they hold. Other public officials may receive compensation, but still choose to seek additional sources of income, either with a private employer or establishing a private business of their own. All of that is totally fine. However, you must not use your position that you hold as a public official to create the opportunity for additional personal income. That is definitely prohibited. You must also ensure that there is a clear distinction between the use of your personal resources and time for your income producing activity and the use of your public body's time and resources. So two little separate silos. Keep them separate. Now, the law also prohibits us from directly or indirectly soliciting or accepting the promise of future employment based on the understanding that the offer is influenced by our official votes, actions, or judgments. So making sure that we don't make any deals with outside agents or agencies where you'll recommend certain education changes, for example, in exchange for benefits or future employment. Now, if you're offered a job, there's a few questions you need to ask yourself before you can accept it. The first is the job opportunity only available because of your position as a public official? And second, was the job opportunity created because of your position as a public official? So if the answer to either of these two questions is yes, then it is probably a prohibited use of position violation to accept the offer. Additionally, both current public officials and former public officials may not attempt to further their personal gain through the use of confidential information that was gained during the course of their work with the public body. So this could look like using upcoming education changes that aren't public yet to give your own business a head start, or even starting your own continuing education program based on changes that only the board knows. Can't do that. And ORS 244 has special provisions related to contracts and subsequent employment. So a public official who has authorized a public contract cannot legally work under that contract for a period of 2 years from the date of authorization. Now, the word authorized has a definition of meaning you're performing a significant role in the authorizing of that contract. So that could be signing the contract, selecting a contractor, serving on the selection committee, recommending approval, etc. Now, this restriction does not apply to a person who is a member of a group that is performing a significant role but did not participate in the authorization or was not present when it was authorized. Just a side note on that. All right, now OGEC has created some guidelines for public officials to follow in order to avoid violating government ethics law when engaged in private employment or personally owned business. Now, these are in our guide for our public officials, which is on our website, which I will show you towards the end of this. But the guidelines include a few things we've already mentioned, but they are not using any governmental body time, not using any governmental body resources, taking no official action that could financially impact your private enterprise, not using any confidential information obtained through your position as a public official, and disclosing all conflicts of interest. So those are the requirements there. And we have another knowledge check. Okay, you've seen this before, but here we go. So in addition to being a board member, you also own your own business. Can you promote your business in the following situations? And here we go. This is multiple choice. Your options for this, excuse me, are A, in your personal LinkedIn account, B, in the agency break room after a board meeting, C, at a conference where you have been invited to be a speaker as a board member, or D, during board meetings. So please go ahead and make your selections. Don't worry about not seeing them on the screen. And Lex, I'll wait for you to let me know they're ready.
You might be one short because I accidentally logged myself out, so I have to log back in.
Uh-oh, no worries.
Okay, with that, then we are ready to move forward.
Excellent. Okay, glad you spoke up. There we go. All right. And so for this example, the only situation would be in your personal LinkedIn account. Any of the others start to get into that area where we are not separately keeping our official duties and actions separate. Oh, okay. Look at that. It just popped up. Excellent. Okay. Technology is great and also sometimes a great mystery. All right. So most of you got that right. Excellent. You know, of course, we like to throw some questions in there that make you think, but this would be the only situation where it is truly separate from your official duties as a board member. All right. Any questions on this section?
I do have a question. Is sort of stating your role on the board really promotion if you're acting in your sort of personal capacity? You're a speaker at a realtor conference, and they note this is a board member of the real estate agency, and they also work at ABC Realty. It's not a promotion. They're not handing out flyers. They're not offering marketing deals, anything like that. It's a recognition of the different hats they wear where they reside in. And they're generally speaking in a private capacity, but noting their role as a board member. Yeah, or I mean, they're not directly employed by the state, but appointed by the governor. And they are public officials in that capacity. But, you know, the credentials that they hold, the roles that they hold, including the role as a public official.
Now, as the newest member of OGEC, I'm going to throw this question over to Lex or Stephanie.
Yeah, no, that's not, yeah. So in that situation, yes, that's something we like to say, like your experience is owned by you. So that would be the kind of same thing as having in your LinkedIn that, yes, you are a board member as well as your real estate position and things like that. It is fine just to state, I am on the board in whatever your private capacity, because that is a fact. You are a board member. So that is okay. Just making sure you're not using that to get a benefit, right? Like trying to use your connections, those kinds of things. But just if you're at a conference and saying, I'm on the Oregon Real Estate Board, and also that wouldn't be use of office violation.
Thank you.
And Stephanie, yeah, I think Stephanie has more to add. So go ahead.
Yeah, I was just going to say it would be different if you were there in your capacity as a board member, right? If you were invited to speak as a board member, because then the issue is if someone approaches you and says, I would like to work with you in your real estate capacity, but they only know about you because of their interaction with you as a board member, then that would be using your position for financial gain. So it is a very nuanced thing, and you have to kind of weigh those two pieces. So Lex is 100% correct in the scenario you presented, where you're there in your private capacity. That is one thing, but when you are there in your public capacity, you do have to keep that in mind.
Thank you.
You know, I can also think, I would like your feedback on this. For example, they're in a public meeting like that, and if you would say things like, you should really hire me because not only am I a realtor, but I also serve on the board. I've got this added credibility. That's like a blatant promotion to say, hire me because of what I do.
Correct. Yeah. Or Stephanie, if you want to go.
No, go for it, Lex.
Okay. Yeah. No. So, and that would be something where you would be using your position to try to get that, right? You're trying to say, yes, hire me because of my position. That is different than if you are applying for a position and just on your experience, you list your board. That is one thing. But actually saying, oh, hire me because I'm a board member, because of my public official position, there's again, nuance there. That's how we'd weigh the two differences. Does that make sense? Perfect. Cool.
Yeah, thank you.
Yeah,
Great
definitely. Great.
questions.
Yeah, definitely. Okay,
Right,
Angela,
and
take it back.
You can see why they're here with me today, the experts. All right, so we're going to just quickly touch on nepotism. And this is essentially, these are rules that apply to your relatives or your household members per the definitions that Lex covered with you earlier. Now, when we talked about conflict of interest, after you first comply with all of the conflict of interest provisions, which most often require from refraining from participating, public officials cannot directly engage in any personnel action taken by our public employer that would impact the employment of our relative or a member of our household. Additionally, we can't participate in any interview, discussion, or debate taken by our public agency that would impact the employment of our relative or member of our household. There is an exception for something called ministerial acts. Those are things like mailing and filing forms or correspondence, taking and relaying messages, scheduling appointments, or preparing documents or meetings. Minutes for public meetings, excuse me. Those are allowed, not prohibited. You can also serve as a reference or provide a recommendation for a relative who has applied for a position of employment, promotion, or is subject to a personnel action. Additionally, you can't directly supervise a relative or household member unless your public body adopts a policy specifying when we as public officials can act in an official capacity and may directly supervise a person who is a relative or member of our household. There are exceptions, of course, everywhere. So there's an exception to the nepotism provisions, but it only applies to unpaid volunteers who provide services to the public body in an unpaid capacity. So a public official can supervise and participate in personnel actions of relatives or household members who are unpaid volunteers. All right, now I'm gonna just jump past this because I want to make sure we don't run out of time for some of the other stuff we're going to cover. Any questions on that? Okay, gifts is a bigger section. So let's talk about gifts. All right, so how do we determine if something given to us is a gift, and how do we determine if we can accept it as a public official? Well, Oregon government ethics law establishes a framework of conditions for public officials to apply when they, their relatives, or members of their household are offered gifts. If offered something, we must analyze the offer and decide if it is a gift and if it can be accepted. Now, an important note, this only applies when a gift is given to an individual. So us as public officials, if the gift is received by an agency or office rather than an individual, it would be the responsibility of the director or head of the agency to determine how to handle the receipt of the items. I'm also going to mention, I love a good visual aid. We have a gift flow chart that covers everything I'm about to talk about on our website. I will point that out to you when we get to that section. So, all right, so let's say that the agency is sending you to a conference and attendees of the event consist of colleagues, stakeholders, vendors, and members of the general public. And a vendor at the event is handing out a free swag bag. Side note, I love a free swag bag and free Costco samples, but how do we know if we can accept it? So we're going to kind of use this scenario as we go through gifts to figure that out. So first we have to figure out if it is a gift. So Oregon state law's definition of a gift is as follows. It is something of economic value that could also be forgiveness of debt or a discount. It's given without equivalent payment or other consideration. It's given to a public official or a public official's relative or household member. And it is not offered to others who are not public officials, their relatives or household members on the same terms and conditions. So Oregon government ethics law does not prohibit us from accepting gifts. So don't leave the presentation today saying they said we can't accept gifts. You can definitely accept gifts, but it does place a direct responsibility on each of us to understand what circumstances may prohibit us from accepting a gift. So let's also look at what's not considered a gift. So something of monetary value that is supplied to a public official by their employer or agency is not a gift. So if it's coming from them, it would be analyzed or looked at as part of that official compensation package that we talked about before. So salary, health benefits, etc., not a gift. A gift given to a public official that is available to the general public as under the same terms and conditions is not a gift. So if Dutch Bros is giving out free coffee, also let me know which one and where, then that would be not considered a gift if it's being given to anybody that just rolls through the drive-through between 8 and 9 on Thursday, whatever. If you get a mailer in your neighborhood and everybody in that neighborhood gets mailed the same thing, free passes for an upcoming event, not considered a gift under Oregon government ethics law. All right, so let's go back to the scenario. So again, just to recap, you're going to this conference. Attendees are colleagues, stakeholders, vendors, and members of the general public. And a vendor at the event is handing out a free swag bag. So is the swag bag a gift? Let's answer the following questions to make that determination. Again, handy visual guide that we have available if you need that in the future. So first question, is it something of economic value? Well, we're going to say yes to that. Is it given to a public official? You're there, you're a public official, it's being given to you. Yes. Is it being given without equivalent payment? Well, they're just sitting on that table in front of the, the vendor swag bags. So yes, it's being given without equivalent payment. But now the last question, is it being offered only to public officials, their family and household members, or is it being offered to others on the same terms and conditions? Well, in this case, no, it's not being offered only to just you as a public official, your relatives or household members. It is being offered to others on the same terms and condition, which means this swag bag is not a gift and you can take as many of them as you want. Don't say I said that, but yes, you can. Just joking. Okay, but let's just change it up a little bit. So what if we change it and now the conference is only for public officials? No vendors, no stakeholders, none of that. That changes the analysis. And if it is only open to public officials at this point, then it would be considered a gift. And if we sort of go with that analysis moving forward, we can see what we need to do to figure out if we can accept that as a gift. All right, so in order to know what the restrictions are on a particular gift, we need to know 3 things. So first, who is the source of the gift? Second, does that source have a legislative or administrative interest in our actions, decisions, votes, or recommendations while we're acting in our official capacity? And last, what is the value of the gift? So that first question, who is the source? So if something meets the definition of the gift, then we need to figure out who the source of the gift is. And the law defines the source as the ultimate payer of the expense. Now, we may or may not always know who the ultimate payer of the expense is, so it's our responsibility to find out who the actual source of that gift is that's being given to us. So let's say you attend a completely different conference, and at that conference you win a tablet in a raffle. Congratulations. You would need to determine who actually purchased the tablet. So was it the event organizer? Was it a vendor at the event? Was it another individual? The burden lies on the receiver of the gift, so us as individual public officials, and not on the giver of the gift. So what happens when something is given anonymously, making it virtually impossible to identify the source? Are you then able to determine whether the source has any economic interest in us as public officials? Well, no, you're absolutely not. So our agency advises that if you receive something where the source is anonymous and you're not able to return the gift, that you donate it to a nonprofit. You would make sure to keep the documentation of that donation, but do not take any tax benefit for the donation, as that could be receiving a financial benefit for the item. All right, so now that we've identified who the source of the gift is, we go through that analysis. We then have to determine if that source has a legislative or administrative interest in our decisions, actions, or votes, and whether that interest is different from that of the general public. So a legislative or administrative interest means that the source has an economic interest, and that economic interest involves a monetary gain or loss that could or would occur from actions taken by the public officials' decisions, actions, or votes. And it is different or distinct from that of the public because the economic impact or interest is not felt or experienced by members of the general public in the same manner as the source of the gift. So some examples of interests that are distinct from that of the general public include things like, let's say you've got a private contractor, they would have an economic interest in a public body's authority to award contracts. Real estate developers would have an economic interest in a public body's authority to approve subdivision applications. Textbook publishers or distributors have an economic interest in a public body's authority to award contracts and purchase books. So many votes or decisions made by public officials have the same general economic impact on all members of the general public. But if the source does not have a legislative or administrative interest in what we do as a public official, then there is no gift limit. But what if there is an economic interest? So you know the source, you know they have a legislative or administrative interest in you as a public official, then you need to look at gift limits. So during a calendar year, a public official, candidate, relative, or member of the household may not solicit or receive, either directly or indirectly, any gifts with an aggregate value in excess of $50 from any single source that could be reasonably known to have a legislative or administrative interest. So let's say that we have the authority to approve permits or certifications, contracts, and purchases for the source of a gift. We would have to limit our acceptance of gifts from that source to $50 per calendar year. So again, just to reiterate, you can accept gifts, but if there's that legislative or administrative interest, you have to be aware of, it limits it to $50. So that could be one $50 gift, two $25 gifts, five $10 gifts, etc. As long as you don't exceed that $50 limit for the calendar year, you're free to accept it. Now, if a group of people wanted to pool their money to pay for a more expensive item to give as a gift, then the receiver of the gift would have to make sure that they have not received more than $50 in value from each individual person total during the calendar year. If the source does not have that economic interest in the decisions that we make as a public official, the gift limits don't apply. And I know I'm saying a lot of stuff, but again, look at that flow chart. That will clarify everything for you. And in that case, we would be free to accept the gift, even if it was more than $50. All right, so let's look at this scenario. So sort of an easy way to demonstrate a legislative or administrative interest in our actions as public officials is to think about giving gifts between our coworkers and managers. So we could have an administrative interest in those higher up because they have a say in our employment and our leave requests and our salary, etc. So they have to monitor and limit their receipt of gifts from us to $50 in a calendar year. On the flip side, however, we can receive gifts without limitation from our managers and coworkers that are higher ranking from us, as we don't have any say in their leave request, salary, etc. So if you want to demand donuts every day of the week for the entire year from that person, you can absolutely do that. So once again, the provisions only apply when the giving of the gift is going bottom up and not top down. Let's revisit this scenario again. So can you accept the swag bag? So ultimately the answer here is yes, as long as the swag bag and any other gifts that you've received from the organizers during this calendar year has been less than $50. And why? Well, when the conference is only open to public officials, then the vendor and conference organizer is going to have a legislative or administrative interest in the public official paying to attend the conference. All right, so we're going to recap some of our options when we're offered a gift. After going through the process to identify if something is a gift, our first option is just to accept it, assuming that we're under that $50 limit or there's not a legislative or administrative interest. If you can't accept the gift because the source is anonymous, or maybe it was worth more than $50 and there was a legislative or administrative interest, you can accept the item on behalf of your agency, and then the agency gets to decide what they want to do. You can politely decline the offer, just explain what's going on and why you can't accept it. Or we already talked about, you can donate the gift. Just don't take any sort of tax benefit. Ultimately, the best option depends on your circumstances. All right, now there are 16 exceptions to the gift definitions that you can accept without limit. So they're basically not considered gifts. Gifts are benefits that are offered at no or reduced cost. We'll go over a few of the exceptions, but if you would like a more in-depth explanation, we do have a separate gifts webinar that goes into all of this information. So you can accept gifts from relatives, as we've already defined, or members of your household. No limit there. Unsolicited tokens or award of appreciation in the form of a plaque, trophy, desk item, wall memento, or similar with a resale value reasonably expected to be less than $25. If it's an item that has materials worth more than $25, you may actually have to give some of that back. One example is the vase in this photo, a removable vase worth more than $25 just in materials. The person was able to keep the base that had the information on it, but had to return the base portion. Attendance at receptions, meals, or meeting are another exception. So this is to allow public officials to attend organized planned events and engage with members of organizations when representing their government body. This exception does not authorize private meals where the participants engage in discussion. Private meals could be considered a gift and would be subject to the gift restrictions we just talked about. Food or beverages that are offered as an incidental part of a reception at no cost are exempt. This would be like light snacks or refreshments, does not include sit-down meals. This would be at things like social gatherings or meetings where guests are honored, or ceremonial gatherings. Another exception would be entertainment provided to your relative or member of your household where you've been asked to act in an official capacity while representing your employer for a ceremonial purpose. All right, and we're just going to recap this. So if we're offered something of value, we first have to determine if it's even considered a gift by the law. So is it something of economic value? Did you make a payment to receive it? Is it being offered to others who are not public officials nor my relatives or household members? Does it fall within the 16 exclusions, which I know we didn't talk about all of them, but that is something to consider. And then if it is a gift, you need to ask, who is the source of the gift? Is that source reasonably known to have a legislative or administrative interest in my votes or decision-making as a public official? And is the gift within the limitations? All right, so we have one more knowledge check. And I know we're hitting our time that you guys asked us to be here, but you are sent to a conference as a board member. At the conference, you win a raffle for a tablet. Again, congratulations. What questions do you need to ask yourself to determine if you can accept the tablet? This is a multiple choice. I'll read these. A, who is the gift offered to? B, who else has accepted the gift? C, who is the source of the gift? D, is anyone else offering the gift? E, does the source have a legislative or administrative interest in what you do? Or F, what is the value of the gift? And I will again let Lex keep an eye on that. Okay, excellent. All right, so it looks like we
Yeah,
got
I think you're good to move forward.
perfect. I saw the number pop up. Thank you, Lex. All right, so again, this is a multiple choice. So the correct answers were: who is the gift offered to? Who's the source of the gift? Does the source have a legislative or administrative interest in what you do? And what is the value of the gift? All right. Any questions on that segment? Okay. And I have just a few other items to show you real quick. I want to be respectful of your time. Do we have a couple minutes to cover that?
I think some folks might start dropping, and that's possibly okay, Steve, or do we actually have to?
Yeah, I mean, I think
yeah,
you just want to finish up a few things, so that's totally fine.
yeah.
If you do have a hard stop, just I think people are already chatting in the box, so
Yeah.
Perfect.
Just do that. But if you can stick on, let's stick around a little longer. Yeah.
Okay, just a couple more. I'm just sort of
Yeah.
wrapping things up for you here.
Thank you so much. Yeah.
Yeah, no problem. So back at the beginning, we said our goal for this session today is you'd be able to identify the 5 key areas of government ethics law and know where to go if you had specific questions or who to contact. So these are the areas that we covered today: conflicts of interest through gifts. Now, if a complaint is filed, OGEC has a process that we have to file if a complaint is filed against any public official. So anyone can file a complaint alleging that there may have been a violation of Chapter 244. However, we cannot accept any anonymous complaint. So the person has to sign their name to it if they're going to file that complaint. Now, once we've received a complaint, we will notify all parties involved about the process, and only the commission itself can decide if a violation has occurred. If they do find that a violation has occurred, you may be subject to sanctions, which are listed here on the slide. Now, depending on the nature of the violation, most often the commission will issue a letter of education and may require you to take additional training. I would say in probably the vast majority. But before it even gets to the complaint, investigation, or sanction phase, we strongly recommend contacting the Oregon Government Ethics Commission. We've kind of talked about that throughout this entire presentation. We have 3 levels of advice: staff advice, staff opinions, and commission advisory opinions, that each offer a different level of safe harbor protection if a complaint were to be filed. All advice, guidance, and opinions issued by the commission are available to the public, and I'll show you where momentarily. Request for this type of advice can be submitted in writing, by phone, or in person. Our office is open and available Monday through Friday, 8 to 5, and we do take all of those requests. All right, so you can find our resources on the OGEC website, including general information about the agency and its jurisdiction. We have commission meeting information, members of the board. Their information is listed there, as well as staff. The website also shows you how to file a complaint. In our public records section, you can find records for people who file statements of economic interest, lobbyists, etc. I would highlight the public officials section. This is where the Guide for Public Officials is located, as well as other resources. Public meetings law, if that comes up, we have guides, trainings, and more on this topic. And under the advice section, that's where you can view previous advice that's been offered or submit a request for advice. All right, so I think we've covered everything. We always like to ask what your biggest takeaway was from the training. If you want to type that in the chat, or take yourself off mute. All right, and with that, we hope that you enjoyed this session, and we want to thank you for the opportunity to provide training to you today. Does anybody have any final questions for us? seeing any, and I know you guys are running out of some folks are running out of here. So again, thank you for the opportunity. It has been our pleasure.
Thank you so much for presenting today. This is a lot to take in, but it's just really important information. And for some of us, it's a good reminder as well. So it's all good. Mhm.
Thank you.
Yeah.
Thank you.
Right. Thank you,
Thank
everyone.
you all.
Thank
Have a
you.
great rest of your day.
Thank you.
So, Dawn, we just turn it back to you there's really nothing else. Except I know we've got board reports that are submitted in writing. Was there anything else on the agenda, Anna?
There's not anything else in the agenda. We do just need Dawn to state the date of the next meeting and then officially adjourn. So
Officially adjourned, yeah.
should be pretty quick.
Okay, perfect. The next meeting of the Real Estate Board will be held on August 3rd at the Oregon Real Estate Agency office in Salem. And the meeting of the Oregon Real Estate Board is now adjourned.